In the name of Allah, the Beneficent, the Merciful, I bear witness that there is no God but Allah, and I bear witness that Muhammad is his messenger. Greetings to you, our listening audience, and welcome back to Know Your Rights University, Cairo. We wish to indulge in a brief discussion on some trust principles and share with you some similarities between fiduciary duties of a public officer as compared with those of a trustee of a private trust. We're starting our reading off today with some case law discussing common law trust principles applicable to public and private trustees and or fiduciaries. We start with the case of United States versus Mitchell. It was said the necessary elements of a common law trust are present: a trustee, a beneficiary, and a trust corpus. In the case of Leonard Futches versus Arthur Bidwell, we read, it has long been agreed that public officials occupy positions of public trust. A public official, a public office is a public trust, and the holder thereof cannot use it directly or indirectly for a personal profit, and officers are not permitted to place themselves in a position in which personal interests may come into conflict with the duty which they owe to the public. Incident to said trust. They stand in a fiduciary relationship to the people by whom they have been elected and appointed to serve. The relationship between a state official and the state is that of principal and agent, and trustee and cesticate trust, or beneficiary. The relationship has been described as founded in the common law. The saying, public office is a public trust, is more than mere rhetoric. Okay, so let us now define for our listening audience what a trust is. Trust, the right enforceable solely in equity to the beneficial enjoyment of property to which another person holds the legal title. A property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. For a trust to be valid, it must involve specific property, reflect the settlor's intent, and be created for a lawful purpose. The two primary types of trusts are private trusts and charitable trusts. See below. A fiduciary relationship regarding property and charging the person with title to the property with equitable duties to deal with it for another's benefit. The confidence placed in the trustee together with the trustee's obligations toward the property and the beneficiary. A trust arises as a result of a manifestation of an intention to create it. See fiduciary relationship. The property so held. Corpus. Black's Law Dictionary, 8th edition. Fiduciary relationship. A relationship in which one person is under a duty to act for the benefit of another on matters within the scope of the relationship. Fiduciary relationships such as trustee, beneficiary, guardian ward, principal agent, and attorney-client require an unusually high degree of care. Fiduciary relationships usually arise in one of four situations. 1. When one person places trust in the faithful integrity of another, who as a result gains superiority or influence over the first. 2. when one person assumes control and responsibility over another. 3. When one person has a duty to act for or give advice to another on matters falling within the scope of the relationship. Or 4. When there is a specific relationship that has traditionally been recognized as involving fiduciary duties, as with a lawyer and a client, or a stockbroker and a customer, also termed fiduciary relation, confidential relationship, special relationship. From Meacham on public officers, from Meacham on public offices and officers, Section 1, Public Office and Officer defined. A public office is the right, authority, and duty created and conferred by law, by which for a given period, either fixed by law or enduring at the pleasure of the creating power, an individual is invested with some portion of the sovereign functions of the government to be exercised by him for the benefit of the public. The individual so invested is a public officer. An office, says Blackstone, is a right to exercise a public or private employment and to take the fees and emoluments thereunto belonging. An office is a special trust or charge created by competent authority. If not merely honorary, certain duties will be connected with it, the performance of which will be the consideration for its being conferred upon a particular individual, who for a time will be the officer. In the case of Aldom versus Borough of Roseland, it was said, a public office is a public trust. Borough councilmen, as fiduciaries and trustees of the public interests, must serve that interest with the highest fidelity. The law tolerates no mingling of self-interest. It demands exclusive loyalty. The theory is that a public officer assumes the same fiduciary responsibilities towards the citizens of his community as a trustee bears to his cestui trust or beneficiary. They have the right to expect that in everything that appertains to their business or welfare, he will exercise his best judgment, unaffected and undiluted by anything which might inure to his own interests as an individual. From Trustee Handbook, Part 2, Incidents of Trust Estate, Ownership. In every trust, there are two estates, that of the trustee or the legal estate, and that of the beneficiary or the equitable estate. Estate: the amount, degree, nature, and quality of a person's interest in land or other property, especially a real estate interest that may become possessory. The ownership being measured in terms of duration. See periodic tenancy under tenancy. Equitable estate: an estate recognized in equity, such as a trust beneficiary's interest. See equity. A legal estate was a right in rem. An equitable estate, a right in personam. That is to say, the former conferred a right enforceable against the whole world, the latter one which could be enforced only against a limited number of persons. Legal estate: an interest enforced in law rather than in equity. These two estates are separate, although bound together and traveling on parallel lines, and they will be treated separately in this treatise. The trustee's estate here and the beneficiary's estate later on. The trustee's estate consists in the ownership of the property itself, and the beneficiaries in his right in a court of equity to compel the trustee to carry out the provisions of the trust, but not in any estate in the property itself. The tendency in America is to merge legal and equitable rights, and for courts of law to act on equitable principles. Statutes that reduce the legal estate to a mere power, as in New York and other code states, and the refusal of a court of law to allow trust property to be sold on execution, are examples of these tendencies that might be largely multiplied. Nevertheless, a trustee in either court of law or equity is the absolute owner of the trust property as to the whole world, and may eject even the beneficiary from the premises, and is accountable to no one in the world but the beneficiaries for his use of the ownership. The popular error that the trustee is merely the agent of the beneficiary expresses an entirely erroneous and mischievous conception of the trustee's relationship to the property and his beneficiary. In a case of agency, the principal owns the property, and the agent acts in his own name and place. In a trust, the trustee owns the property, acts in his own name, and the beneficiary has no property rights, but a claim against the trustee only. In the case of an agency, the person with whom the agent contracts may sue his principals on the contract. He has no such rights against the beneficiaries in a trust. Incident, adjective, dependent upon, subordinate to, arising out of, or otherwise connected with something else, usually of greater importance. The utility easement is incident to the ownership of the tract. As the owner of the property, all the incidents of ownership fall to the trustee. All actions against strangers, either at law or in equity, for damage to or loss of the property, and all actions to protect or recover it must be brought in the name of the trustee. And the trustee may sue and be sued without any joinder of the beneficiaries. Where the relations between the trustee and beneficiary are not in question, and his interests are adequately represented by the trustee, it was held in a foreclosure suit that the beneficiary had the right to raise money and should therefore be joined, but the weight of authority is otherwise. In some jurisdictions, like Alabama, New York, and South Carolina, beneficiaries are by statute necessary parties. If the beneficiary is in the possession of trust property, he may sue for an injury to his possession to the same extent as any other bailee of property, but as against all the world other than the beneficiary, the trustee's right to possession is absolute and cannot be questioned. If the trustee's right of action is barred by the statute of limitations, or if he loses right of action in any manner, the right is absolutely lost, and the beneficiary is equally barred and has no rights which he can enforce against the property or a stranger. The trustee, and not the beneficiary, is entitled to a vote as stockholder in corporations, and the trustee, as an owner of stock, is eligible as a director, and the beneficiary is not. In the absence of statute to the contrary, the trustee is personally liable as stockholder, even beyond the extent of the trust property, but his liability is generally limited by statute to the extent of the trust estate. Whether he himself has a right to be reimbursed by the trust estate, or whether the creditor can pursue the trust assets, is immaterial to the action. as the ultimate liability of the trust estate cannot be settled in a suit at law. The trustee is personally liable on the contracts which he makes in respect to the trust property, and if he is not bound, nobody is bound. And this fact emphasizes the difference between a person acting as trustee who binds only himself and one acting as agent who binds the principal. Even his co-trustee need not be joined in the action, since the contract is the personal contract of the trustee making it. By using appropriate expressions, the trustee can exempt himself altogether from personal liability or limit his liability to the extent of the trust estate. But it is erroneous to suppose that he does so by describing himself or signing his name with the word trustee or as trustee added. In the case of Schumann Hank versus Folsom, it was said the declaration of trust involved in this case created a business trust and not a partnership. This being true, the trustees had no authority to bind the Setske Trust or beneficiary because a trustee is not an agent. When a trustee contracts, he does so for himself. He has no principal. The contract is the personal undertaking of the trustee, and if he wants to protect himself from individual liability on the contract, he must stipulate that he is not to be personally responsible and the other party is to look solely to the trust estate. In the case at bar, the trustees did limit their liability by specifically stating that the contract was executed, not individually, but as such trustees to bind the trust estate. Under the authorities, this was sufficient. A covenant by trustees, as such trustees, but not otherwise, to repay a loan is a covenant to repay the money out of the trust fund only and does not impose any personal liability upon the trustees. Unless he is expressly exempted from liability by the contract itself, he will be personally liable even on a contract made under order of the court. If he has the power to contract for the benefit of the trust, and if he properly describes himself as trustee, the contract will bind the trust effects in his hands and those of his successor, although recourse will be had to him in the first instance. So too, a trustee will be personally liable on the covenants in a deed or lease, whether he signs as trustee or not. And it is important in this connection to bear in mind that there is an implied covenant for quiet enjoyment on behalf of the lessor in every lease. Taxation. The trustee is personally liable for taxation. In the absence of statute, on the personal property where he resides, and on land where the land lies, but statutes are not unusual, making the personal tax payable where the beneficiary resides who is entitled to the income. When both the trustee and beneficiary are non-resident, the personal property is not taxable to anyone. A statute making the property taxable where the beneficiary lives, when neither the trustee nor the property are within the state, is constitutional. In many jurisdictions, it is the trustee's duty to bring in a list of the trust property for taxation, and in others, he may do so. A trustee who neglects his duty would be personally liable for the penalty of his neglect, and where he neglects his opportunity to file a list and the property is overassessed, and owing to his neglect, the overassessment cannot be recovered, he would probably not be able to charge the overassessment to the trust. personally liable as owner of property. The trustee is personally liable as owner of the trust property in the same way and to the same extent as if he owned the property individually. Thus, he is personally liable for a nuisance on the trust premises, for a defective coal hole or sidewalk, or for snow falling from the roof of a building belonging to the trust estate. So, too, he is personally liable if through operations on the trust property his neighbor's building is unlawfully let down or his land flooded. If the trustee employs servants about the trust business, he will be personally liable for their torts equally as if he had employed them for his own affairs. His liability as stockholders in the corporation has been already noticed. This liability as owner is entirely irrespective of the trustee's right to be indemnified by the trust estate, which it was consistently held could not be adjudicated in a legal action in a court of law. Hence, describing the trustee in the writ as trustee was held to be surplusage. Judgment was entered against him individually, and execution issued against his own goods and not those of the trust. The tendency of courts of law to adopt equitable principles in dealing with trust estates, which has already been referred to, has modified this doctrine, and it is now pretty generally held that where the trustee has a right of indemnity against the trust estate, he may be sued as trustee and execution will issue against the trust property. But if the trust property is insufficient to satisfy the execution, the balance can be collected from him personally. In other words, the plaintiff is subrogated to the trustee's right of indemnity, which is convenient for him, as the trust estate is not infrequently larger than the trustees. The trustee has no right to indemnity from the trust estate where his neglect causes the accident. The law does not allow the trust estate to be diminished by the trustee's neglect or default. Where, however, the trustee has been conducting the trust business reasonably and carefully, he will have a right to be indemnified for judgments recovered against him. As, for instance, where the plaintiff's injured by a falling lamp, although the trustee is using due care in having the wood cut, or where the plaintiff is injured by the careless driving of a servant of a trustee who is lawfully carrying on the testator's business, or where the plaintiff's buildings are let down by mining operations carefully conducted on the trust property. In all these cases, the trustee was held to have a right of indemnity from the trust estate, and the plaintiff was allowed to recover against him as trustee. Reasoning from the analogy of the trustee's responsibility for debts, even in those jurisdictions that deny his right to hold the trust estate in equity, subrogating himself to the trustee's right of indemnity, this indirect remedy would seem to have the disadvantage of making him subject to all set-offs against the trustee. The trustee, as owner of the property, is liable criminally for a nuisance on it and may be indicted under liquor or gambling laws. The trustee's ownership is not beneficial. Although the trustee is the absolute owner of the property, he can take no benefit from his ownership, and he may not deal with the estate for his own profit or for any purpose unconnected with the trust. All the benefits belong to the beneficiaries, and the trustee has no more right to any of them than he has to the property of a stranger. All his skill and labor must be directed to the advancement of the interests of his beneficiaries. He may take no benefit directly or indirectly from the estate or his office, except the regular compensation allowed by law, and if he takes a present or be paid a bonus or commission of any kind in a trust transaction by a stranger, he must account to the trust for it. He cannot set off his own debts in equity against one who sues him as trustee. He cannot use the real estate or chattels or pledge any of the property as security for his debts, nor can he purchase them directly or indirectly at public or private sale, except by arrangement with all the beneficiaries, in which case, excuse me, he does not get a merchantable title, as the burden is on him to show affirmatively that the beneficiaries were all sui juris informed of all the facts and dealt at arm's length. But he may purchase under leave of court or at a judicial sale, which he does not control in any manner. Nor can a husband or wife, being trustees, sell to the other, even though the other be a beneficiary. It is immaterial that the price paid is a fair one. The transaction is a breach of trust and may be set aside by the beneficiary, but no stranger to the estate can question the transaction. If, however, the property be honestly sold to a third person, there being no scheme to repurchase, the trustee is not disabled from buying it subsequently. Similarly, he cannot sell any property to the trust. He cannot speculate with the trust funds under the guise of a loan to himself. If he does, all the profit will belong to the trust. And if the profit does not equal interest, he must pay interest. If there is a loss, he must stand it. He cannot borrow the trust funds on any security, and he should not lend them to his family or associates on any terms. He cannot swell his personal credit by keeping a large balance of the trust funds at his bankers. He cannot come in competition with the trust estate, nor make a profit by buying up claims against the estate at a discount, directly or indirectly. By statute in some jurisdictions, he cannot enforce a claim against the estate acquired, nor make a profit out of the trust in any manner. Where the English rule prevails, which refuses competition to a trustee, he should not employ himself or his partner to render expert services to the estate, or if he does, he may receive no compensation therefor. But in most other jurisdictions, if he could have given such employment legitimately to another, he may render it himself and receive reasonable compensation for his services, as for example, where he acts as counsel, broker, or agent to collect. But the law is not uniform, and in some states he cannot take any compensation. In practice, the matter is a delicate one, and it is a better rule to avoid the difficulty altogether by employing a stranger. But where such employment is allowed, the charge for expert services, together with the regular commission, should not amount to more than reasonable compensation for all the services rendered. He must pay over to the trust any bonus in the performance of his duties or for resigning the trust, but he need not account for the profit which he receives from other business owing to the fact that he is a trustee. May have expenses from the trust fund. On the other hand, the trustee should not be a burden, and the trustee may pay from the estate all the expenses which he incurs as owner, such as taxes, repairs, and insurance, and he may charge the estate irrespective of the provisions of the settlement with all the legitimate expenses of management as traveling expenses, the cost of justifiable litigation, and expense of consulting counsel when there is reasonable cause, and if he be not at fault, judgments recovered against him as owner of the property, or where the employment is reasonable and usual, the expense of brokers or agents, or the expense of looking after the beneficiary, as for instance having him declared insane and placed under guardianship, and in some states the premium paid a surety company on his official bond may be charged to the estate. Ordinarily, the expense of accounting, not including court expenses, and clerk hire and office rent are included in the ordinary allowance made as compensation, and so are not charged to the trust. But where it is necessary to keep a clerk exclusively for a particular trust, it will be the ground for an extra charge. He has no lien on the estate for his expenses and may reimburse himself out of income or hold possession of the corpus of the estate until he is paid. But if he has exceeded his powers, has been guilty of a breach of trust, or is in default, or has denied the trust and involved the estate in litigation, I believe this is an error right here. So we're going to reiterate this and hopefully get some clarity later on and come back and clarify. But I believe this should say he has a lien on the estate for his expenses and may reimburse himself out of income or hold possession of the corpus of the estate until he is paid. But if he has exceeded his powers, has been guilty of a breach of trust, or is in default, or has denied the trust and involved the estate in litigation before incurring expense, he may require security if there is doubt about his being reimbursed, and he has a right to his costs prior to all charges. Compensation. The whole matter of compensation is subject to the provisions of the settlement. In the absence of these, in England and Delaware, the trustee cannot charge for services. But in all the other states, he is entitled to reasonable compensation. The amount of the compensation is fixed by statute or rule of court and is usually by way of commission on the gross income collected and ranges from 5 to 10%. The court usually allows the highest amount paid agents, factors, and the like for performing similar service. The trustee may agree as to amount of commission with the beneficiary if the beneficiary is competent to act, and no undue advantage is taken, and the court should take the agreement into consideration in fixing the amount of compensation. Although the amount to be allowed rests in the absence of provision by the settlement or statute and the sound discretion of the court, the judgment is not conclusive on persons not properly parties to the case. Duty of loyalty. The trustee must administer solely in the interests of the beneficiaries. This is similar to the exclusive benefit rule under ERISA that requires retirement funds to be managed for the exclusive benefit of retirees. I believe ERISA means Employee Retirement Insurance Security Act. The two main indicators of this loyalty occur when the trustee engages in self-dealing or ignores a conflict of interest. Self-dealing occurs when the trustee buys or benefits from the sale or purchase of trust property directly or indirectly. Self-dealing occurs when the trustee buys or benefits from the sale or purchase of trust property directly or indirectly. One more time. Self-dealing occurs when the trustee buys or benefits from the sale or purchase of trust property directly or indirectly. If the trustee engages in self-dealing, good faith and fairness to the beneficiaries are not enough to save the trustee from liability. In case of self-dealing, the court makes no further inquiry. Therefore, the trustee's good faith and the reasonableness of the transaction are irrelevant. The beneficiaries have several remedies when the trustee engages in self-dealing. First, the beneficiaries can hold the trustee accountable for any profit he made on the transaction. In the event the trustee has sold his own property to the trust, the beneficiary can sue to make the trustee return the purchase price and take back his property. The trustee is not without defenses when it comes to self-dealing. In order to avoid liability, the trustee must prove that the settlor authorized the self-dealing or that the beneficiaries consented to the transaction after he made full disclosure. Nonetheless, the transaction must be fair and reasonable. A conflict of interest occurs when the trustee facilitates the sale or purchase of trust property to a person or entity to which the trustee also owes a fiduciary duty. For example, if an attorney who is acting as trustee sells trust property to one of his clients, a conflict of interest arises. The court will evaluate the transaction to see if it was fair and reasonable to the trust. In that case, the trust pursuit rules provides a remedy for the beneficiary. Under that rule, if the trustee wrongfully disposes of trust property and acquires other property, the beneficiary is entitled to enforce a constructive trust on the newly acquired property so acquired. Hence, the new property becomes a part of the trust assets. In the event that the trust property ends up in the hands of a third party, there are two possible results. If the third party is not a bona fide purchaser, one who pays value and takes without notice of a breach of trust, he does not hold the trust property free of the trust. If the person is a bona fide purchaser, he holds the property free of the trust and is under no liability to the beneficiary. The classic example of a self-dealing trustee, however, involves a trustee's purchase of trust property in his individual capacity. A trustee may not sell trust property to himself or his spouse, privately or by auction, even if the sale is made in good faith and for adequate consideration. Presumption: a legal inference or assumption that a fact exists based on a known or proven existence of some other fact or group of facts. Most presumptions are rules of evidence calling for a certain result in a given case unless the adversely affected party overcomes it with other evidence or rebuts the presumption. A presumption shifts the burden of production or persuasion to the opposing party, who can then attempt to overcome the presumption. See burden of production. A presumption may be defined to be an inference as to the existence of one fact from the existence of some other fact founded upon a previous experience of their connection. C. Restatement Supra, Note 3, Section 171, Comment E, stating that a sale of trust property by the trustee to his spouse is voidable by the beneficiary because such a sale is considered to be the equivalent of a sale made by the trustee to himself. Also, in the matter of Mente's will, stating that a presumption of self-dealing arises from a sale of trust property by a trustee to his wife or father. But see Uniform Trust Act. No trustee shall directly or indirectly buy or sell any property for the trust from or to itself or an affiliate, or from or to a director, officer, or employee of such trustee, or of an affiliate, or from or to a relative, employer, partner, or other business associate. See Restatement, Note 3, 171, Comment B. See also, in the matter of Downing's estate, the prohibition against self dealing is absolute. Where the trustee violates it, good faith or payment of a fair consideration is not material. In the matter of Bradley's estate, holding that it is immaterial that the trustee acts in good faith in purchasing trust property for himself and that he pays a fair consideration. Arguably, the participation of a trustee at an auction of the trust corpus involves an inherent conflict of interest, since the trustee is forced to wear two hats. Arguably, the participation of a trustee at an auction of the trust corpus involves an inherent conflict of interest, since the trustee is forced to wear two hats. One more time. Arguably, the participation of a trustee at an auction of the trust corpus involves an inherent conflict of interest, since the trustee is forced to wear two hats. As a fiduciary acting on behalf of the trust, the trustee's duty of loyalty mandates that he obtain the highest possible price for the trust asset being auctioned. However, the trustee in his individual capacity represents as opposite competing interests, securing the trust property at the lowest possible price. The incompatibility of these two roles and the competition subsumed within the auction process will likely cause the trustee not only to contravene the principle embodied in Section 171 of the Restatement Second Trust, Comment B, sale of trust property to trustee individually, but also to run afoul of the principle contained in Comment P, competition with the beneficiary. Similarly, an individual or corporate trustee may not sell to the trust property which is being held by the trustee in an individual capacity, or property in which he has a personal interest of such a substantial nature that it might affect his judgment. Subsumed within this dialectic between the phrases might affect and did affect is the ratio legis of the rule against self-dealing by a trustee. The rule against self-dealing is a deterrent and prophylactic rule. Its application is not dependent upon the trustee's unjust enrichment, nor will a trustee escape liability by contending that the self-serving transaction was carried out in good faith. As stated, the principal object of the administration of the rule is preventative, to make the disobedience of the trustee to the rule so prejudicial to him that he and all other trustees will be induced to avoid disloyal transactions in the future. Consequently, if a corporate trustee purchased for the trust shares of stock owned by the corporation's commercial department, it would contravene the self-dealing rules, since there would be a temptation to consider the corporation's advantage in making the purchase and not solely the interests of the beneficiaries. By engaging in such self-dealing, the corporate trustee places itself in a position wherein its interests were or might be in conflict with those of the beneficiary. Surcharge. Verb. To impose an additional, usually excessive tax, charge, or cost. Sense 2. To impose an additional load or burden. Sense 3. Of a court. To impose a fine on a fiduciary for breach of duty. Black's Law Dictionary, 8th edition. An aggrieved beneficiary is not only entitled to petition the court to avoid a self-dealing transaction, but may also move to have a trustee surcharge for any loss to the estate resulting from the self-dealing transaction. In the matter of Tannenbaum's will, the testator's will directed his executors, including his widow, to liquidate his clothing business as soon as practicable after testator's death. Notwithstanding the provision of the will, the testator's widow and co-executrix of his estate continued the business in her individual capacity and also purchased shares in the business from the other executors. The surrogate court held that the co-executrix widow's acquisition of the business and her purchase of the shares from the other co-executors were improper self-dealing and surcharged the executors for the value of the goodwill of the business and for the profits earned by the widow executrix in continuing the testator's business. The surrogate reasoned that when certain actions would be for the best interest of the estate, but possibly involve personal gain or technical conflict of interest, the fiduciary must not proceed without prior authority from the court upon a proper showing. Good faith will not absolve him from the consequence of a violation of his duty. The consequences to the trustee are that any resulting loss to the estate must fall upon his shoulders, though his motives be innocent, and any profit derived from the action will inure to the benefit of the estate, without any compensation for his fruitful efforts, subjecting him to surcharge in either case. The guiding principle by which the court fixes damages in the event of a trustee's self-dealing transaction is the rule that the beneficiaries are entitled to be put in the position which they would have occupied if no breach of duty had been committed. Thus, a beneficiary has three alternative remedies against a self-dealing trustee. First, the trustee is charged with any loss to the trust estate. Second, the trustee is charged with any profit actually made by the trustee through the breach of trust. Third, the beneficiary may recover from the trustee any lost profits which would have accrued to the estate had there been no such breach of trust. Furthermore, if a self-dealing trustee has transferred trust property to a third person, a beneficiary has the right to follow or trace the property into the hands of such third person, unless such third person is a bona fide purchaser without notice of such breach. Moreover, if the trustee has reinvested the trust proceeds into a new traceable investment, the beneficiary has the option to follow such proceeds into the new investment or to hold the trustee personally liable for the proceeds. Examples of breach of trust by public officers. Now let us make observations of these trust principles as applied to public officers who hold positions of public trust. Let us quote some case law, but before we do, we wish to point out that we believe that many of the state legislatures codified or passed statutes and laws which bound public officers to maintain strict standards of ethical conduct. We also believe that certain breaches of trust may exist due to the people's lack of knowledge of our God-given unalienable rights, and therefore we cannot protect such rights if we don't know what they are. That reminds us of the maxim of law that says, he who fails to assert his rights has none. And also in the Bible where it says, my people are destroyed for the lack of knowledge. A public office is a public trust. Borough councilmen, as fiduciaries and trustees of the public interest, must serve that interest with the highest fidelity. The law tolerates no mingling of self-interest. It demands exclusive loyalty. The theory is that a public officer assumes the same fiduciary relationship towards the citizens of his community as a trustee bears to his cestui trust or beneficiary. They have the right to expect that in everything that appertains to their business or welfare, he will exercise his best judgment, unaffected and undiluted by anything which might inure to his own interests as an individual. Now let's point out one of the statutes that state legislators passed to prohibit public officers from using their positions to engage in self-dealing transactions. Section 3A, Public Officer Prohibited Activities Act states, no person holding any office, either by election or appointment under the laws or constitution of this state, Illinois, may be in any manner interested, either directly or indirectly, in his own name or in the name of any other person, association, trust, or corporation, in any contract or the performance of any work in the making or letting of which such officer may be called upon to act or vote. No such officer may represent, either as agent or otherwise, any person, association, trust, or corporation with respect to any application or bid for any contract or work in regard to which such officer may be called upon to vote, nor may any such officer take or receive, or offer to take or receive, either directly or indirectly, any money or other thing of value as a gift or bribe or means of influencing his vote or action in his official character. Any contract made and procured in violation hereof is void. The legislative intent in enacting these statutes was to codify sweeping prohibitions against public officials and officers engaging in conduct which divides their loyalty between their personal interests and their fiduciary duties. The statute is unique because only public officials can violate its provisions. These officials are held in public trust and owe a fiduciary duty to the people they represent. The high standard of conduct demanded of public officers, coupled with the broad sweeping language of the statute, permits no other interpretation as to its intent and meaning. Elements of a breach of fiduciary duty. Under Illinois law, upon which this theory is based, recovery for a breach of fiduciary duty requires proof of three elements. 1. A fiduciary duty exists. 2. That the fiduciary duty was breached. And 3. That such breach proximately caused the injury of which the plaintiff complains. It has long been established in Illinois that a public officer occupies a fiduciary relationship to the political entity on whose behalf he serves. The most well-known of a public official's fiduciary duties is that of undivided loyalty to the office and the people whom he serves. Emanating in part from Section 3 of the Illinois Corrupt Practices Act, now Public Officer Prohibited Activities Act. This duty is sweeping and commands a public official to refrain from self-dealing and conflicts of interest. The duty of loyalty is not the only fiduciary duty Illinois recognizes for its public officials. Other duties may be prescribed by statute or found in common law. The right to a civil remedy for a breach of a statutorily created fiduciary duty is clear. In 63C, American Jurisprudence, Public Officer, Section 3, Nature as Public Trust or Agency, West Key Number Digest, Officers and Public Employees, 1 states, every public office is created in the interests and for the benefit of the people and belongs to them. Thus, a public office is a public agency or trust created in the interests and for the benefit of the people. Such trust extends to all matters within the range of the duties pertaining to the office. Section 4, generally. The characteristics or elements of a public office include its creation by law, that is, by statute or constitution, the designation of the position as an office, the prescription of the qualifications and duties of the appointee, the exercise of some portion of the sovereign power, a permanent or continuing position, not occasional or contractual, a fixed term of office, oath and bond prescriptions or requirements, liability for misfeasance or nonfeasance, and an independent of the official beyond that of employees. In the case called, in the matter of Associate Judge Lewis versus Morgan Jr., held before the Illinois Courts Commission, it was said, the judicial article of the Illinois Constitution provides in pertinent part, Section 13, prohibited activities. A. The Supreme Court shall adopt rules of conduct for judges and associate judges. B. Judges and associate judges shall devote full time to judicial duties. They shall not practice law, hold a position of profit, hold office under the United States or this state or unit of local government or school district or in a political party. Section 14. Judicial salaries and expenses. Fee officers eliminated. Judges shall receive salaries provided by law, which shall not be diminished to take effect during their terms of office. All salaries and such expenses as may be provided by law shall be paid by the state, except that appellate, circuit, and associate judges shall receive such additional compensation from counties within their district or circuit as may be provided by law. There shall be no fee officers in the judicial system. Illinois Constitution of 1970, Article 6, Sections 13 and 14. Illinois Supreme Court Rules. Canon 1, Rule 1.1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety in all of the judge's activities. Canon 1, Rule 1.2. Rule 1.2, promoting confidence in the judiciary. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. Comments. 1. Public confidence in the judiciary is eroded by improper conduct and conduct that creates the appearance of impropriety. This principle applies to both the professional and personal conduct of a judge. 2. A judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other citizens and must accept the restrictions imposed by the code. 3. Conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. Because it is not practicable to list all such conduct, the rule is necessarily cast in general terms. 5. Actual improprieties include violations of law, court rules, or provisions of this code. The test for appearance of impropriety is whether the conduct will create in reasonable minds a perception that the judge violated this code or engaged in other conduct that reflects adversely on the judge's honesty, impartiality, temperament, or fitness to serve as a judge. Rule 3.15, Reporting Requirements. Canon 3, Rule 3.15. A judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the obligations of judicial office. A judge shall file annually with the clerk of the Illinois Supreme Court a verified written statement of economic interest. Conflict of interest. The conflict of interest theory is based on the fact that an individual occupying a public position uses the trust imposed upon him and the position he occupies to further his own personal gain, and that it is the influence he exerts in his official position to gain personally in spite of his official trust, which is the evil the law seeks to eradicate. In the case of Wright versus D'Armand, it was said, conflict of interest statutes address a problem of compelling importance to a state's capacity to govern justly, preventing political corruption or the appearance of corruption. In a case decided by the Illinois Supreme Court finding a prohibited conflict of interest was People versus Charlo. In Charlo, city commissioners negotiated and approved a settlement of a federal lawsuit against the city. In the settlement, they included an arrangement for their own employment with the city. The court stated that the commissioners had a duty to act in the best interest of the city and to refrain from using their positions as city commissioners for their own personal benefit. The court found that the commissioners, in negotiating and approving their own employment with the city, had obtained a personal advantage in violation of state statutes. In Cohen versus Keene, the complaint alleged that Keene used inside knowledge gained from his position as alderman and chairman of the Committee on Finance of the City Council to ascertain the location of various proposed land development projects. Acting through others, he purchased at scavenger sales various tax delinquent parcels located within those areas. Legal title to these properties was placed in the land trust in which Keene held a substantial beneficial interest. Some of the property he acquired at that time was subject to the liens of unpaid special assessments. Keene recommended to the city council, without disclosure of his interest, that the council clear those liens, and the council adopted his recommendations. After the liens had been cleared, Keene used his official position and influence to induce several other governmental units to purchase the properties which he had purchased. The Supreme Court of Illinois stated if these allegations had been proved against a defendant occupying a fiduciary position in the private sector, they would establish that the defendant had exploited his fiduciary position for his personal benefit. A public officer's fiduciary responsibility, the court said, cannot be less than that of a private individual. Keene's private interests would necessarily affect his judgment, as well as that of other aldermen whose vote might have been different had they known of Keene's personal interests. Therefore, the court reversed the lower court's dismissal of the complaint, saying that these were important matters which the public was entitled to have considered. Fiduciary duty law is a crucial legal concept that governs the relationship between individuals or entities entrusted with responsibilities to act in the best interests of others. In the state of Illinois, as in many other jurisdictions, fiduciary duty law plays a central role in various contexts, including business, finance, estate planning, and more. What is fiduciary duty? Fiduciary duty is a legal obligation that requires an individual or entity known as a fiduciary to act in the best interest of another party, known as the beneficiary or principal. The fiduciary duty imposes a high standard of care, loyalty, and honesty on the fiduciary, ensuring they prioritize the beneficiary's interests above their own. Key principles of fiduciary duty law in Illinois. 1. Duty of loyalty. Fiduciaries in Illinois are bound by a duty of loyalty, which means they must put the interests of the beneficiary above their own. They should avoid any conflict of interest and disclose any potential conflicts when they arise. 2. Duty of care. Fiduciaries are required to act with the utmost care and diligence in managing the beneficiary's affairs. This includes making informed decisions, conducting due diligence, and acting prudently. 3. Duty of disclosure. Fiduciaries must provide the beneficiary with all relevant information about the management of their affairs. This transparency helps the beneficiary make informed decisions. Consequences of breaching fiduciary duty. In Illinois, as in other jurisdictions, breaching fiduciary duty can have serious legal consequences. Beneficiaries or harmed parties can take legal action against the fiduciary, seeking damages and potentially removing the fiduciary from their role. Elements of breach of fiduciary duty. The elements of breach of fiduciary duty are similar under the law in several states. In Illinois, the plaintiff must demonstrate that a fiduciary duty existed, that it was breached, and that the breach proximately caused the injury of which the plaintiff is complaining. In the matter of Downing, it was held a purchase by a bank acting as trustee of property for the trust, which was formerly held by the bank's commercial department, is improper not only where the property sold to the trust was properly owned by the trustee absolutely, but also where it was property in which the trustee had an interest of such a substantial nature that it might have affected its judgment in making the purchase. A pledgee's interest in collateral security may constitute a personal interest of a substantial nature in the security so held within the meaning of the rule prohibiting a trustee from self-dealing. Restatement, Trust, Section 170, Comments H, cited. The prohibition against self-dealing is absolute. Where a trustee violates it, good faith or payment of a fair consideration is not material. The test in cases like the present is whether the trustee has a personal interest of such a substantial nature that it might affect his judgment. Restatement, Trust, Section 170, Comment H. After establishing the limits of the fiduciary duty at issue, the litigant should evaluate who has the burden of proving a breach of the fiduciary duty and whether the facts dictate a shift of the burden of proof to the defendant. Burden of proof of partners, trustees, agents, and non-statutory fiduciaries. Generally, plaintiffs have the burden of proving each element. 1. The existence of a fiduciary duty. 2. Breach of that duty. And 3. Damages directly stemming from that breach. Model Jury Instructions, Business Torts Litigation, American Bar Association Section of Litigation, 4th edition, 2005. Arizona, Arkansas, California, Colorado, New York, Oklahoma, Pennsylvania, and Washington have jury charge instructions that clearly set out that it is the plaintiff's burden to prove breach of fiduciary duty. The majority of the states place the burden of proving each element of a breach of fiduciary duty on the plaintiff. However, the burden of proving a breach may shift where the defendant fiduciary has profited or benefited from the transaction with the beneficiary. Keck, Mahin, and Kate versus National Union Insurance Company of Pittsburgh, finding that when a fiduciary profits or benefits in any way from a transaction with the beneficiary, a presumption of unfairness arises that shifts the burden of persuasion to the fiduciary to show that the transaction was fair and equitable to the beneficiary. In this circumstance, the defendant bears the burden of proof on the second element, whether the defendant breached the fiduciary duty. Where a fiduciary business advisor was an officer director of a museum, but was also advising his sisters to donate their estate to the museum, there was a presumption of unfairness that the fiduciary needed to rebut. International Bankers Life Insurance Company versus Holloway, holding the burden of proof on the fiduciaries to prove fairness where the fiduciaries were engaging in transactions for their personal profit. The presumption of unfairness operates to shift both the burden of producing evidence and the burden of persuasion to the fiduciary. To prevail, the defendant must prove that the questioned transaction was fair and equitable to the beneficiary. The fiduciary made reasonable use of the confidence that the beneficiary placed in him or her. The fiduciary acted in the utmost good faith and exercised the most scrupulous honesty toward the beneficiary. The fiduciary placed the interests of the beneficiary before the fiduciary's own, did not use the advantage of his or her position to gain any benefit for himself or herself at the expense of the beneficiary, and did not place himself or herself in any position where his or her self-interest might conflict with his or her obligation as a fiduciary, and the fiduciary fully and fairly disclosed all important information to the beneficiary concerning the transaction. Trust instrument. The formal document which creates the trust and contains the powers of the trustees and the rights of the beneficiaries. It may be a deed in trust or a formal declaration of trust. See also trust deed. The terms of trust created by written instruments are determined by the provisions of the instrument as interpreted in light of all the circumstances and such other evidence of the intention of the settler with respect to the trust as is not inadmissible. Restatement, Second Trust, Section 4, Comment D. The extent of the duties and powers of a trustee is determined by the rules of law that are applicable to the situation, and not the rules that the trustee or his attorney believes to be applicable, and by the terms of the trust as the court may interpret them, and not as they may be interpreted by the trustee himself or by his attorney. Trust principles make a deferential standard of review appropriate when a trustee exercises discretionary powers. See Restatement, Second of Trust, Section 187, where discretion is conferred upon the trustee with respect to the exercise of a power. Its exercise is not subject to control by the court except to prevent an abuse by the trustee of his discretion. A trustee may be given power to construe disputed or doubtful terms, and in such circumstances the trustee's interpretation will not be disturbed if reasonable. Whether the exercise of a power is permissible or mandatory depends upon the terms of the trust. Hence, over a century ago, we remarked that when trustees are in existence and capable of acting, a court of equity will not interfere to control them in the exercise of a discretion vested in them by the instrument under which they act. See also Central States, Southeast and Southwest Areas Pension Fund versus Central Transport Incorporated. Excuse me. In the case of Gene Bryan versus Scott Chittle, it was said, we also note that a trial court possesses discretion to determine whether to impose one of the remedies listed in RC 5810.01, wills, at paragraph 20 and paragraph 31, emphasizing that RC 5810.01 states that a court may choose among the listed remedies. Thus, reviewing courts will not disturb a trial court's decision regarding the RC 5810.01 remedies unless the court abused its discretion. In the matter of testamentary trust of Ham, citing Whitaker versus the state of Whitaker, a probate court's imposition of damages and its calculations regarding the correct amount due the trust will not be disturbed absent a showing of abuse of discretion. Quoting, in the matter of a state of Pizzoferrato, a probate court's decision relative to an assessment of damages is a discretionary one that a reviewing court will uphold absent an abuse of discretion. Wills at paragraph 16. Trial court decision regarding damages under RC 5810.01 remedies, including damages subject to abuse of discretion review. The term discretion itself involves the idea of choice, of an exercise of the will, of a determination made between competing considerations. In order to have an abuse of that choice, the result must be so palpably and grossly violative of fact or logic that it evidences not the exercise of will, but the perversity of will, not the exercise of judgment, but the defiance of judgment, not the exercise of reason, but instead passion or bias. This concludes our reading for today of this document. We hope that it has been informative and of some benefit to you in your endeavors to gain knowledge for inclusion of freedom, justice, and equality, and to free yourself and make light our burdens by the gaining and an acquiring of knowledge, of requisite knowledge. Thank you for listening. Once again, peace and blessings to you all.